Okay, over the weekend I did a video on exposing the fraudulent nature of the liens and levies being filed and used by the Internal Revenue Service routinely across the United States as a matter of this is how we operate. It's all done fraudulently. And in that I mentioned that in order to do the lien or levy enforcement procedures, it was necessary to be a person liable for tax. And I said I'd come back to that, and then I never did. So I thought I'd throw this video on to look at the issue of liability for tax. You see here, Code Section 6321, lien for taxes, and the first requirement is if any person liable to pay any tax. If you neglect or refuse, the amount shall be a lien in favor of the United States. Okay, so you have to be liable to pay tax. Now, this liability has to be laid in statute, otherwise the courts can't enforce it. The courts can only enforce what's in the statutes. If you're presumed to be liable or inferred to be liable or assumed or presumed to be liable, that's not sufficient. The court cannot enforce a presumption and assumption. They can only enforce what's been written in the law. That's it. So in order to be a person liable to pay tax, you have to be made liable by statute for the payment of the tax. So this is a requirement, a pre-existing prerequisite requirement for their being allowed to file a lien. It can only be filed against the party liable for the tax. 6331, levy and distraint, the exact same thing. Authority of secretary, subsection A. If any person liable to pay any tax neglects or refuses to pay the same, it shall be lawful for the secretary to collect such tax by levy upon all property and rights to property belonging to such person, or on which there is a lien, because in order to do the levy beforehand, to enforce collection of a claimed amount, they need to first secure the claim as a legal claim by filing a lien in the courthouse records. And as I explained in the other video, the liens are all forged. When the IRS files a lien, you should file suit in the state court for forgery, fraud, and counterfeit. The reason why you file in the state court is because if the government, federal government, DOJ, removes an action from state court to the federal court, the federal court can no longer dismiss the action for lack of subject matter jurisdiction, which is what they like to do when you file the original complaint in the federal court. Dismissed for lack of subject matter jurisdiction, you're out. But if you file in state court and DOJ removes it to federal court, the federal court can't dismiss it. If they lack subject matter jurisdiction, they have to remand it back to the state court for the trial on the forgery, fraud, and counterfeit grounds. Forgery is a crime and a civil action, both under state law and federal law. So they can't escape this. They're going to have to let you depose the two agents whose names are forged on the, or one of whose name is forged on the bottom of the lien, and that's going to be the end of the action. Doesn't matter whether it's in federal court or state court. It's crime to forge somebody else's signature on a land conversion instrument. You have the requirement again, in order to make levy, first they had to be a person liable to file the claim and make it a legal claim. Then you have to be a person liable in order to enforce the claim by levy through the taking of property. So if you didn't see the hour-long video I did over the weekend, you might want to look at that. But right now we're going to go look at liability for withheld tax. Here you go. We have section 7501. This is all Title 26. And 7501, liability for taxes withheld or collected. Whenever any person is required to collect or withhold any internal revenue tax from any other person, and to pay over such tax to the United States, the amount of tax so collected or withheld shall be held to be a special fund and trust for the United States. And this section makes the collectors liable for turning over the tax that they've collected in a certain way. Okay? Other statutes. Well, here's one, 2032A and 2056A specifically state who is liable for the estate taxes. 3102B states who's liable for the FICA tax. 3202 states who's liable for the railroad retirement tax. 3505 And liability for employment taxes. 4002, 4003 specify who was liable for luxury passenger tax. 4051 and 4052, heavy trucks and trailers. 4071, tire manufacturer. 4219, you see all of these taxes. Wages, occupational, use tax, petroleum, chemicals, qualified employer pension plans. Failure to satisfy continuous coverage requirements, tax on failure to meet certain group plan requirements, all of these taxes, distilled spirits, wines, distilled spirits, wine imported in bulk, beer imported in bulk, manufactured tobacco products, every single one of these taxes has a statute that makes the person liable for the payment of the tax so that the court can enforce the payment of the tax against some party under law, who's made responsible by law through the liability statute for the payment of the tax. And if there's no liability statute, the court can't act. So what are the last ones? Well, we get the subtitle A, the income tax, 1461 and 1463, which are laid out both here. And the person required by law to pay the subtitle A income tax, the party made liable for the tax, is every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax and is hereby indemnified against the claims and demands of any person. Now, it references this chapter. This chapter is chapter 3, which is part of subtitle A, which is chapters 1 through 6. It's the body of legislation enacted in 1913 as the federal income tax, which was enacted under the Underwood-Simmons Tariff Act of October 3rd, 1913. A tariff is an impost. A tariff is one form of an impost, and an impost is one of the 3 indirect powers the Constitution authorizes Congress to tax. But impost taxation only taxes foreign persons, foreign activity, foreign imports, activity in foreign places like territories and possessions or in foreign countries under tax treaties. Impost is the power to tax foreign activity, which the federal government is given full jurisdictional control over by the Constitution, both foreign persons and foreign imports, and by treaty, activities in foreign countries of citizens. And the withholding agent, the person required to deduct and withhold, turns out to be a whole class of persons called withholding agents, defined in law at 7701A16. And when we look that up, we see that the withholding agent is only authorized, allowed, and required to collect tax from non-resident aliens and foreign corporations because it's a tariff on foreign activity. And that's the only requirement to collect the tax. And that's the only liability in statute, is the liability of the collector to turn over what is collected from these foreign persons. And 1463 says, well, if the collector doesn't collect the tax, but if the tax is paid by the recipient of the income, in other words, the non-resident alien or foreign corporation, well then, if any person in violation of the provisions of this chapter fails to deduct and withhold any tax, and thereafter the tax against which said tax may be credited is paid by the foreign party, the tax so required to be deducted and withheld shall not be collected from such person. So they're not going to collect the tax from the withholding agent because it was paid by the person who it was actually imposed on, the non-resident alien or the foreign corporation. This doesn't reference how that might be done, but that's what it's inferring. And after the collector doesn't have to pay the tax because it was already collected and paid by the non-resident or foreign person, but this section shall in no case relieve such person, the collector, from liability for interest or any penalties or additions to the tax otherwise applicable in respect of such failure to deduct and withhold. Oh, isn't that interesting? The interest and the penalties on failure to pay aren't paid by the non-resident alien, the person who is supposed to pay the tax. It's paid by the withholding agent who failed to deduct and withhold the tax. Shouldn't be any interest and penalties imposed on the worker. All is imposed on the person who failed to collect. Of course, if you ignore these collection provisions and pretend it's a direct tax that everybody has to pay on their own labor instead of being an indirect tax that is only collected by withholding agents from foreign persons under the Tariff Act, Well, then you're enforcing communism, not constitutional taxation, because constitutional taxation says you only collect this income tax from non-resident aliens and foreign corporations, and then the people that collected it are the parties liable for the payment of the tax. And here it is, 1461, 1463. If there's anybody in this country, any attorney, any judge, any person, anywhere in this country, anywhere on the planet, who can point to another code section in Subtitle A, Chapters 1 through 6 of Title 26, that makes any party liable besides the collector, I'd sure like to hear about it. But for 35 years, nobody has been able to do it. Not the government, not the DOJ, not the judges, not the Supreme Court, not all the media writers, not all the media mouthpieces, not all the people lying to you and deceiving you and cheating you into this communistic practice of direct taxation in place of and in violation of the constitutional taxation the government has a limited authority to collect on labor and fruits of labor derived from the exercise of the right to work only on foreign persons, not citizens. And here's the statutes that make them liable. Now, how would any lien or levy ever be filed against the person who isn't liable for the tax? Yeah, that's a good question, isn't it? Because there's only one way to become liable for the tax. Actually, I guess there are two. One is this statute to collect the tax. The other is to voluntarily assess yourself on a Form 1040, and when you sign the bottom line, you make yourself liable for the amount assessed. And that's why they need you to file the return. Is because if you don't file the return, they can't assess the tax. And you're not liable under statute for the payment of any. And isn't it interesting? Here, 35 years later in 1945, they implement the exact same withholding system in Subtitle C. The exact same system. Here it is, Subtitle C, 3403, right after 3402, which is collection of the tax at the source by allowance from the employee. And here's 3403 for the employers, 32 years after the income tax in 1913, where it's only the withholding agents, the collectors, who are made liable. And in Subtitle C, 33 years later, they do exactly the same thing. The employer shall be liable for the payment of the tax required to be deducted and withheld under this chapter, and shall not be liable to any person for the amount of any such payment. Just like the withholding agent is relieved of liability from those that he collects from, the employer too is relieved of liability from those that he collects from, and he only collects from people who ask him to do so, unless they're non-resident aliens. Then he's required to collect it as a withholding agent and as an employer. But if it's a citizen, he can't collect the tax unless you ask him to do so, because there's no tax imposed on your salary, and that no one can force you to pay a tax before it's legally due next year on April 15th without violating the 13th Amendment's prohibition on involuntary servitude. You can't force me to service a tax obligation that does not yet exist in law and may not ever exist, but definitely won't exist until April 15th of next year. I'm sorry, I need the use of my funds until then. Bidenomics aren't working out for me. I want my whole paycheck. I'll settle up with the tax man on April 15th if he can show me where I'm liable. Well, there you have it. You need to be liable to be subject to lien or levy. There is no liability anywhere in statute. The only liability that exists is the liability of the withholding agents in Subtitle A from the 1913 legislation, chapters 1 through 6 of Title 26, and the liability of the employer from the 1945 Subtitle C legislation, chapters 20 through 25, 21 through 25. That's it. Same scheme of taxation in both systems. It's indirect collection of the tax at the source, liability in the name of the collector, all completely constitutional, all 100% indirect, where the burden of the tax is shifted by the collectors who never pay the tax out of their own pocket. They only turn over what they have collected from other parties as the subjects of the tax and the tax collection. They don't pay out of their own pocket. And it is only the tax collector, the withholding agents, and the employers who are actually the taxpayers in this scheme. The other people are not the taxpayers because they're not given a duty in law to interact with the Treasury to pay over a liable tax. You can make yourself a taxpayer by voluntarily performing an assessment on a Form 1040, which isn't required at law and isn't allowed to be used by the IRS in a substitute for return procedure. So if you don't file the return, they can't legally perform an assessment. The whole thing is nothing but a criminal extortion scheme. That's section 6201 if you wanted to look that up. They can assess unpaid taxes payable by stamp, alcohol, tobacco, and firearms. Article 1, section 8, excise taxation. Oh, but that authority extends to taxes shown on return. So if you file a return, they can review it and alter the assessment. But if you don't file a return, they can't legally file one for you. They have to commit fraud, forgery, and unlawful conversion of property in order to collect anything, or they have to get a court to enforce the second plank of the Communist Manifesto against you instead of remaining limited to the impost duty and excise powers, which are the only powers, the only taxing powers in the Constitution that are made enforceable at law by a constitutionally authorized Congress under an enabling enforcement clause that applies to the power granted. The original necessary and proper enabling enforcement clause enforces the original constitutional powers to tax by impost duty and excise indirectly, and they also enforce the power to tax directly, but only with apportionment to the states, which means the Constitution can only enforce direct taxes against the states, not the American people, regardless of the 16th Amendment. The reason why is because the 16th Amendment has no enabling enforcement clause in it to authorize Congress at the constitutional level to write law to enforce any alleged power allegedly created by the amendment. And if you're alleging that after the amendment now you can tax directly labor with no limitations, well, obviously that would be a new power, because before the 16th Amendment, all direct taxes had to be apportioned to the states and laid in proportion to the census. If you've eliminated those powers, allegedly, to allow direct taxation under the amendment, you need an enabling enforcement clause to authorize Congress to write law in order to enforce that new power. It doesn't exist. The judges have been lying to the American people. They have betrayed the American people. They are the enemy of the American people with respect to this system of unconstitutional taxation, involuntary servitude, and slavery, which they are enforcing in place of legitimate taxation. So, I don't think we need to go any further. If you're interested, I've laid all of this out in the videos that expose the entire income tax fraud. They're laid out in a series of 4 videos. I'll put them into the same playlist as I'm putting this in, because this is the information you've been denied as a people. Denied the law, denied the knowledge of it, and denied the application of it properly by the courts that are enforcing the second plank of the Communist Manifesto, which reads a heavy, progressive, or graduated income tax. That's where you find graduated taxation. The Constitution requires uniformity and doesn't allow graduated brackets to be imposed on the American people. The use of brackets goes back to the 1880s in a series of Supreme Court decisions where they ruled that the use of tax brackets came out of the power of Congress to discriminate against the inanimate commodities and articles of commerce subject to taxation and certain inanimate persons like corporations. But let me ask you, what power does Congress have to discriminate against citizens on any basis? Race? National origin, color, religious belief, gender, wealth? Where would that come from? Where would the basis to discriminate on wealth or income or property or assets. Where would that basis come from? That's right, the second plank of the Communist Manifesto, a system of class warfare. Not uniform treatment of the people, class warfare, so that the people can be set at warfare with one another, in lawfare, riots, any means possible, orchestrating an invasion, fentanyl, drugs, so that the people can be set at warfare with one another. And while both classes, all classes, are warring with one another, they never notice it's the political class that's looting the treasury, enriching themselves, their families, their business partners, and their allies around the world, while rendering the American people virtual peons, serfs, and slaves to the international banking cartel that controls the monopoly on currency and credit in every country on the planet. Good luck. You're going to need it until you get rid of the income tax. This is what's destroying America. Till we get rid of it, the politicians will be ruling you instead of representing you. And I'm sorry, but that's just the way it's going down. And if you don't see that by now, you better start reading and listening to this material, because that's where you're being taken. TaxFreedom.com, tax-freedom.com, IRSZoom.com gets you help with liens or levies for just $50. And Thomas Freed channel on YouTube is where all this information gets laid out short and sweet in 1-minute videos and a series of 1-hour videos that walk you through the income tax step by step, showing you the Constitution, the law, the statutes, the language, the regulations, and the implementation details that expose the fraud from top to bottom, which are being kept hidden from the American people in order to keep this system of peonage debt service running for another 100 years or so. Okay, Thomas Freed, taxfreedom.com, IRSZoom.com. Pick yourself up a copy of The Simple Truth About Income Tax over at IRSZoom.com for just $4. It lays out everything that I was talking about as the back-end explanation for what we just did this morning on liability. You need to pick that up, read the book. It's $4. I'm giving away freedom for $4. I mean, that's as cheap as it's going to get. That's as cheap as it's going to get. Okay, we'll be back with more later.